Please be seated. The sitting is open. I would like to note that today the following judges are present with me in the Great Hall of Justice: Vice President Gevorgyan and Judges Tomka, Abraham, Yusuf, Sebutinde, Iwasawa, Nolta, and Charlesworth, and Judges Ad hoc, Pillay and Kress, while Judges Benuna, Shway, Bandari, Robinson, and Salam are participating by video link. The Court meets today to hear the first round of oral argument of the Gambia. I shall now give the floor to the agent of the Gambia, His Excellency Mr. Dauda Jallow. You have the floor, Your Excellency.
Madam President, honorable judges, it is an honor to address you today as the agent of the Republic of the Gambia in our dispute with the Republic of the Union of Myanmar. Over 2 years ago, the Gambia filed its application with this court, exercising its right as a party to the Genocide Convention to hold Myanmar to account for its ruthless acts of genocide against the Rohingya group in Myanmar. My esteemed predecessor said that he stood before you then, as I do now, to awaken the conscience of the world and to arouse the voice of the international community. The court rose to that challenge and unanimously ordered provisional measures against Myanmar that have, to this very day, helped protect the Rohingya group from a repeat of the violent acts of genocide that Myanmar's military, the Tatmadaw, had inflicted upon them. We must never forget the Tatmadaw's mass murder, its coordinated use of rape and sexual violence as a weapon of genocide, its burning of villages with people locked in their homes, its targeted killing of children and the elderly, its murder of people as they fled these so-called clearance operations, and its order to kill all that its soldiers could hear and see. Justice and accountability for those acts of genocide and for Myanmar's ongoing acts of genocide is not just possible, it is necessary. A solemn obligation shared by the Gambia, every state party to the Genocide Convention, and the international community as a whole. It is why the international community drafted and adopted the 1948 Genocide Convention. It is why the Gambia filed its application against Myanmar over 2 years ago. It is why the United Nations, the organizations of the Islamic Cooperation, and the states around the world have welcomed and supported the Gambia's case. And it is why the Netherlands and Canada have publicly announced their intention to intervene under Article 63 of the court statute. It is why this court must reject Myanmar's meritless preliminary objections and proceed to adjudicate the merits of this dispute. Madam President, honorable judges, the Gambia may be a geographically small state, but we stand tall in the international community of states and take pride in promoting and protecting human rights and international accountability for atrocity crimes like genocide. We work bilaterally with other states and through multilateral institutions in our sovereign capacity for these and other national goals. It is a statement to the Gambia's diplomacy. It is a testament to the Gambia's diplomacy that the 57 member states of the OIC formally endorsed and supported our action before this court, not to mention the many others who have subsequently done the same. We are no one's proxy. As my predecessor told you at the outset of this case, this is very much a dispute between the Gambia and Myanmar. We seek to protect not only the rights of the Rohingya, but our own rights as a state party to the Genocide Convention by holding Myanmar to its acknowledgement party's obligation and not to commit genocide, not to incite genocide, and to prevent and punish genocide. These violations of the Genocide Convention are a stain on our collective conscience, and it would be irresponsible to pretend that it is not our business. We make it our business when we, as civilized nations, committed ourselves to the pact under the 1948 Genocide Convention. At the last oral hearings, Myanmar raised the very same objections that are before the court now. The court rightly rejected them in its order of provisional measures. Nothing has changed that would warrant the court to depart from its previous unanimous decision, and we call on the court to swiftly reaffirm its previous rejection of these groundless objections. Now, even more than before, justice within Myanmar is impossible. And now, as before, only this court can hold Myanmar to account for its acts of genocide. Madam President, honorable judges, justice delayed is indeed justice denied. The Rohingya and all people of Myanmar deserve justice and accountability. The Gambia is grateful that the court has settled these hearings so that this case may proceed without further delay. As a state party to the Genocide Convention, the Gambia fully expects that the court will uphold its right to have this case heard on the merits. The Gambia urges the court to proceed as expeditiously as your careful deliberations allow. The Rohingya deserve no less. The Gambia is proud to be represented by a diverse team of international advocates who will address all of Myanmar's preliminary objections in turn. Mr. Paul Reigler will speak first to update the court on the developments in this dispute since 2019. Mr. Andrew Lowenstein will then demonstrate what should be the obvious point, that the Gambia is the applicant state and not acting as a proxy for any other entity. Professor Per Dejean will establish the Gambia standing to bring this case as a state party to the Genocide Convention. Next, Ms. Tafazwa will show that Myanmar's reservation to Article 8 does not deprive the court of its jurisdiction, which is explicitly provided for under Article 9 of the Convention. Mr. Asalan Suleiman will confirm that a dispute existed between the Gambia and Myanmar over its violations of the Genocide Convention as of the time the application in this case was filed. And finally, Professor Philip Sands will provide concluding remarks for the Gambia's first round of arguments. Madam President, honorable judges, it remains for me to thank you for your courtesy, for your keen attention to this case, and for allowing me to address you. With your permission, I would ask that you called upon Mr. Reigler to address you virtually. Thank you very much.
I thank the agent of the Gambia for his statement, and I now invite Mr. Paul Reigler to take the floor. You have the floor, Mr. Reigler.
Madam President, members of the court, good afternoon. It is, as always, an honor for me to appear before you. It is a special privilege to do so in this case on behalf of the Gambia and to speak in support of its efforts to protect the Rohingya people in Myanmar from destruction as a group by the respondent state, and to prevent further state-initiated acts of genocide against them by holding Myanmar accountable under the Convention on the Prevention and Punishment of the Crime of Genocide. Madam President, a lot has happened since the parties last appeared in this court in December 2019. Two major events stand out above the rest. First, in January 2020, the court indicated provisional measures. Second, 1 year later, in February 2021, Myanmar's armed forces, the Tatmadaw, overthrew the elected civilian government. They then filled top governmental positions, including Prime Minister and Deputy Prime Minister, with the same senior Army generals whom United Nations bodies have accused of responsibility for the acts of genocide that, according to their findings, were committed against the Rohingya people between 2016 and 2018. These two overarching events and their consequences set the context in which these hearings on Myanmar's preliminary objections are taking place. My remarks today will be addressed to them and the implications they have for the remainder of the proceedings in this case, including Myanmar's effort by means of its preliminary objections to escape the court's jurisdiction. Madam President, there is good news and bad. The good news is that the provisional measures indicated by the court in January 2020 are having an effect. To be sure, they are not as effective as they might be, and in no sense is Myanmar fully complying with them, as the Gambia has made clear in its observations on Myanmar's periodic reports. But the court's measures have helped to prevent the worst from happening. In particular, there has been no resumption of the clearance operations that the Tatmadaw carried out against the Rohingya population with such devastating brutality and effect in prior years. There have been no new mass killings of Rohingya, no new mass rapes or gang rapes of Rohingya women and girls, and no new burning of populated Rohingya homes and villages with families locked inside. The Gambia attributes the absence of such overtly genocidal acts to the existence of the court's provisional measures and its ongoing exercise of jurisdiction and oversight. Myanmar's military junta has been impervious to pleas of restraint from around the world, including from members of the United Nations Security Council, other UN bodies and agencies, and neighboring states. None appear to have had any influence on its behavior, except for the court. Even after the coup of 1 February 2021, the military government has continued to submit reports on its alleged compliance with the court's provisional measures order. It has appointed a new agent. It has retained new counsel. And it has appeared at these hearings to plead its case on preliminary objections. Plainly, by its actions, it has shown that as a party to these proceedings, it will not or dares not disregard the court. In these circumstances, maintaining the existing provisional measures in effect is essential for the protection and survival of the estimated 600,000 Rohingya who remain in Myanmar today. The court's measures are the last and only remaining constraint on the military government's policies and practices toward this extremely vulnerable and existentially threatened group. Even under elected civilian rule, prior to February 2021, the Tatmadaw was a law unto itself, especially in regard to its treatment of the Rohingya. As Myanmar's then agent, who is now imprisoned and incommunicado, explained in December 2019, quote, under its 2008 constitution, Myanmar has a military justice system. Criminal cases against soldiers or officers for possible war crimes committed in Rakhine must be investigated and prosecuted by that system, end of quote. If there was no accountability in Myanmar for acts of genocide committed by military personnel then, there is certainly none now. This is because the individual authors and perpetrators of the genocide against the Rohingya, the very same military leaders most responsible for planning it and carrying it out, are now openly in charge of the government. Any restraints on their behavior that an elected civilian government or the image of democratic legitimacy might have provided have been cast aside. The Tatmadaw now exercise all state power nakedly and directly, and that is the bad news. And it is still worse. The devils are in the details. The main architect of the military coup, Senior General Min Aung Hlaing, was the principal architect of the Rohingya Genocide, according to the United Nations fact-finding mission, whose 2018 and 2019 reports formed part of the factual basis for the Gambia's provisional measures request. After the coup, Senior General Hlaing appointed himself Prime Minister. Serving immediately under him as Deputy Prime Minister is Vice Senior General So Win. The UN fact-finding mission found him responsible as Commander-in-Chief of the Tatmadaw for directing the clearance operations against the Rohingya, including the deployment of combat divisions to Rakhine State for the purpose of eradicating them. Other Tatmadaw officers and head key government ministries and agencies. This includes the acting president, Lieutenant General Myint Swe. As chair of the Investigation Commission for Maung Daw, he found that there were absolutely no cases of genocide or religious persecution in the region. This demonstrated, in the views of the UN Special Rapporteur on the situation of human rights in Myanmar and the Special Advisor on the Prevention of Genocide, a complete lack of independence. Not surprisingly, despite a plethora of so-called investigation commissions, as described in the Gambia's memorial, no one, not a single military officer or enlisted person, has ever been accused, let alone convicted, of genocide, either under the military regime or during the prior civilian government. Madam President, there is presently no national or international body or institution of any kind to which Myanmar's current leaders have acknowledged accountability in any way, except as they continue to demonstrate for this court. That explains why they persist in pursuing their preliminary objections, the very same ones that the court already rejected on a prima facie basis in its order of January 2020. If they can escape the court's jurisdiction, they will be accountable to no one, and there will be no constraints on their persecution and ultimate destruction of the Rohingya. The evidence gathered by United Nations bodies since the February 2021 military takeover demonstrates that this is still the Tatmadaw's objective. According to the UN Special Rapporteur, in a report dated 2 September 2021, at tab 2 of our judges' folders, the estimated 600,000 largely stateless Rohingya in Rakhine State continue to face existential threats and remain discriminated against in accessing citizenship, freedom of movement, and other fundamental rights. Since the coup, the junta has demonstrated that it intends to ensure that the Rohingya remain disenfranchised and segregated. In particular, the special rapporteur stated, also at tab 2 of our folders, as are the rest of the materials I will be displaying, since the coup, the junta has continued to deny the existence of the Rohingya while keeping them disenfranchised through their unresolved legal status, institutional discrimination, human rights abuses, restrictions on their movement, and limited access to livelihoods and essential services. Among other forms of discriminatory treatment that threaten to destroy the Rohingya as a group, the junta, quote, the junta continues to force or coerce Rohingya to accept the National Verification Card, NVC. The NVC process, the NVC process continues to require Rohingya to self-identify as foreigners, and as such, remains an administrative tool to erase Rohingya ethnic identity. In an official public statement issued last month, on 7 January 2022, Myanmar's Ministry of Foreign Affairs criticized the International Organization for Migration for its use of the term Rohingya. Myanmar steadfastly rejects the term Rohingya, which has never existed in legal and historical records of the country, and the people of Myanmar do not recognize it. The military government continues to block citizenship for Rohingya in innumerable ways and to deny them the fundamental rights that only citizens can enjoy, including those rights regarding birth and marriage. Rohingya people continue to face discriminatory laws and policies blocking their access to citizenship, documentation, and civil registration, despite legislative commitments to universal birth registration. Under the 2019 Child Rights Law, the birth of Rohingya children continue to not be systematically registered. Updating civil registration records, including birth and marriages, through the household list remains a challenge, negatively affecting access to legal documentation, basic services, and freedom of movement. The statelessness, internment, and movement restrictions maintained by the junta deny the Rohingya access to the basic necessities of life and leave them especially vulnerable to destruction by the state. There are an estimated 130,000 stateless Rohingya who remain confined in internment camps in Rakhine State, and those in villages throughout the state face increased movement restrictions and are continually impeded from accessing citizenship, services, and livelihoods. As a result, the Rohingya remain at grave risk of mass atrocity crimes. As a result, the Rohingya remain at grave risk of mass atrocity crimes. Madam President, the Special Rapporteur here recalls what human experience has long taught us, that it is just a short step from dehumanizing a people to killing them en masse. In the words of Simone Weil, on the eve of the Holocaust that would soon unfold, quote, once a certain class of people has been placed by the temporal and spiritual authorities outside the ranks of those whose life has value, then nothing comes more naturally to men than murder. The Tatmadaw have shown, both historically and since they have assumed direct power in Myanmar, that Rohingya lives have no value to them. This is especially true of Rohingya women and girls, who continue to be victims of singularly destructive policies and practices. The UN Special Rapporteur, in his latest report, called particular attention to the, quote, detention and forced labor among women and girls living in internment camps. And he cited reports that, quote, Rohingya women and girls are trafficked regularly from internment camps in Rakhine State. The Gambia quoted extensively from the Special Rapporteur's latest report in its observations on Myanmar's fourth compliance report filed with the court on 7 December. It calls out here in these proceedings before the one institution to which the Myanmar authorities purport to remain accountable, Myanmar's ongoing policies and practices that threaten the survival of the Rohingya people. The Gambia does so in hopes that, out of respect for the court, those authorities will feel compelled to untighten the noose they have placed around the Rohingyas' necks. 2 days ago, in these proceedings, the agent from Myanmar extolled his government's approach to the repatriation of hundreds of thousands of Rohingya refugees who fled the country during the clearance operations to avoid destruction at the Tatmadaws' hands. Here is what the Special Rapporteur said about this subject just 2 months ago in a statement issued on 19 December 2021. The relentless assault by the Myanmar military junta's attacks on its own people, as well as the systematic land clearance in Rakhine State, and the ongoing system of discrimination against the Rohingya in law and practice continue at this time. This means that the conditions for the safe, sustainable, dignified return of the Rohingya to their homeland currently do not exist. It will take considerable time and significant effort to create such conditions in Myanmar. Madam President, my colleagues who follow me today will demonstrate one by one why each of Myanmar's 4 preliminary objections has no merit whatsoever. The court was correct in rejecting them on a prima facie basis 2 years ago, and Myanmar has failed to make them any more meritorious in the time since then. Not in its written pleading of 20 January 2021, and certainly not in its oral presentations on 21 February 2022. Notwithstanding their lack of substance, Myanmar has already benefited from filing them. It has stopped the clock on the merits phase of the case for over a year since the objections were filed in January 2021. In so doing, it managed to obtain a lengthy delay in the filing of its counter-memorial, which may not be due until sometime next year. Meanwhile, the agony of the Rohingya is extended further. Human Rights Watch, in its latest report on Myanmar, issued on 7 December 2021, had this to say about the delay in these proceedings. Quote, "The court will next hold hearings on the preliminary objections Myanmar filed 10 days before the coup. There is no quick route to justice in Myanmar, but never has the call for it been louder. The Gambia trusts that the court will hear this call for justice again, just as it did at the provisional measures phase. In the circumstances, we hope for a prompt judgment from the court. We have no doubt that the judgment will be based on the facts and the law, and that it will be rendered in an objective and impartial manner. We pray that the case will then move forward as expeditiously as possible through the merits phase to its just conclusion. Madam President, members of the court, I thank you for your kind courtesy and patient attention, and I ask that you call upon my colleague, Mr. Andrew Lowenstein, to address Myanmar's first preliminary objection.
I thank Mr. Reichler, and I now invite Mr. Andrew Lowenstein to address the court. You have the floor.
Madam President, members of the court, good afternoon. It is an honor to appear before you and to do so on behalf of the Gambia. I will address Myanmar's first preliminary objection. This objection, in effect, asks the court to erase the Gambia's name from its application and to replace it with the Organization of Islamic Cooperation on the asserted ground that the OIC, and not the Gambia, is somehow the real applicant. On the basis of this substitution, Myanmar argues that the court lacks jurisdiction because only states and not international organizations may be parties to disputes before the court, or alternatively, that the application is inadmissible for the same reason. The objection lacks any basis in law or fact. I begin with the law. The relevant requirements for the court to exercise jurisdiction, ratione personae, are clear and straightforward. They are rooted in Article 92 of the UN Charter, which provides that the court shall function in accordance with the UN, with its statute. The pertinent provisions of the statute are located in Articles 34 and 35. Paragraph 1 of Article 34 provides that only states may be parties in cases before the court. Paragraph 1 of Article 35 then provides that the court shall be open to the states parties to the present statute. Tellingly, Myanmar did not mention Article 35 on Monday. That is perhaps not surprising. The provision is fatal to its argument. Article 35's use of unqualified mandatory language, shall be open, permits no exception to the requirement that the parties to the statute are entitled to have access to the court. Since Article 93, paragraph 1 of the Charter stipulates that all members of the United Nations are ipso facto parties to the statute, the Gambia, by virtue of its UN membership, is ipso facto a party to the statute as well. Accordingly, by operation of paragraph 1 of Article 35 of its statute, the court shall be open to the Gambia. Since both the Gambia and Myanmar are parties to the statute of the court and also parties to the Genocide Convention, the Gambia is entitled to invoke the court's jurisdiction in accordance with Article 9 of the Genocide Convention. This, Madam President, should be the end of the matter. So how does Myanmar try to fashion its objection? As you heard on Monday, it advances the novel argument that the court can disregard the fact that the Gambia is the applicant and decide that some other entity is the real applicant. As you will have noticed, Myanmar could not cite a single instance in which this court or its predecessor, or indeed any international court or tribunal, has ever suggested, let alone denied, that the applicant state is the real applicant. Nor, as far as the Gambia is aware, has any respondent state ever before asked an international court or tribunal to do so. Indeed, Myanmar could not even cite a single commentator, anyone, who supports this unprecedented theory. The reason is plain. Under Article 35, Paragraph 1, states that are members of the United Nations are entitled to seize the court in accordance with an applicable basis for jurisdiction, such as Article 9 of the Genocide Convention. As Professor Rosen has observed, every state which is a party to the statute has the right to invoke the jurisdiction of the court in accordance with the general conditions for the exercise of that jurisdiction. It was precisely this right that the Gambia invoked when the Gambia commenced the present proceedings. Myanmar had nothing to say on Monday about Professor Rosen's commentary on jurisdiction. Myanmar, nonetheless, asks you to ignore the application and attempt to discern why, or on whose alleged behalf, the Gambia commenced these proceedings. Now, putting aside the fact that the Gambia brought the case because it has a dispute with Myanmar regarding its violations of the Genocide Convention, a matter to which I will return, the question of what motivated the Gambia to commence the case is wholly irrelevant as a matter of law. As the court held in paragraph 52 of its judgment on jurisdiction and admissibility in Nicaragua v. Honduras, the court cannot concern itself with the political motivation which may lead a state at a particular time or in particular circumstances to choose judicial settlement. The court's case law has thus been clear that it does not matter whether the Gambia's motivation for bringing the case was its outrage over Myanmar's genocidal acts, the urging of other members of the international community, a proposal by the OIC, or any other reason. As the court held, none of this has any relevance for the exercise of its jurisdiction. There is good reason for this. As Professor Tamushat has observed, the court's holding that any possible political motivation of an application is irrelevant for the discharge of its judicial function would seem to be the court's final word on the issue. That is because, Professor Tamushat further observed, the court would emasculate itself if it refrained from agreeing to clarify the legal position in disputes of great importance for peace and security. Myanmar did not address Professor Tamushat's commentary either. So, how does Myanmar make its argument? On Monday, while conceding that the applicant's motivation is irrelevant to the exercise of jurisdiction, Myanmar argued that its objection is not based on the Gambia's motivation, but rather on whether the Gambia is the real applicant. This artificial formulation provides Myanmar no help at all. Myanmar's thesis for why the Gambia is not the real applicant depends on proving that the Gambia commenced the case at the OIC's behest, rather than for its own reasons. That is inevitably a question of motive, the very definition of which is a cause or reason that moves the will and induces action. As the court has ruled, such factors are irrelevant to the exercise of its jurisdiction or the admissibility of an application. Nor is Myanmar helped by arguing, as it also did on Monday, that whether the Gambia is the applicant is a question of substance that calls for objective determination. Even if that were correct, all the court would need to determine objectively is whether the Gambia is a party to the statute of the court. The UN Charter specifies how this is done. Parties to the Charter are ipso facto also parties to the statute. So, to the extent there is anything to be objectively determined, it is accomplished by verifying that the Gambia is in fact a member of the UN. As the Gambia indisputably meets that qualification, the requirements for jurisdiction ratione personae are satisfied. For the court to decide otherwise would be truly extraordinary. Turning now to the facts. The Gambia is, by any measure, the real applicant. On Monday, Myanmar tried to cast doubt on that reality by referencing an eclectic variety of websites, articles, tweets, and press releases. But Myanmar deliberately glided over the evidence that matters. And in making this argument, it was surprising to hear its counsel contend that the Gambia has said nothing about the events leading to the case. That is simply not true. So let's begin with what the Gambia has in fact said about the case. Madam President, the then agent and Attorney General of the Gambia, Mr. Abubakar Marie Tambadou, himself a former war crimes prosecutor at the International Criminal Tribunal for Rwanda, told the court why the Gambia brought the case and how it came about when he addressed you at the opening of the Provisional Measures hearing. He explained this in very direct terms. He recounted how he had visited the refugee camps in Bangladesh as part of an OIC delegation, and how, as he listened to the stories of the refugees, he could smell the stench of genocide from across the border in Myanmar. And he explained how he heard stories of helplessness in the face of mass killings, of mass rape and mass torture, and of children being burnt alive in the sanctuary of their homes and places of worship. The stories of these victims, the Gambia's agent told you, were all too familiar to me from a decade and a half of interaction with surviving victims of the Rwandan genocide. He further explained why the plight of the Rohingya had a particular resonance for the Gambia and why the Gambia was motivated to act. He told you 22 years of a brutal dictatorship in my own country has taught us that we must use our moral voice in condemnation of the oppression of others, wherever it occurs around the world, so that others will not suffer our pain and our fate. And so, the Gambia assumed a leadership role in mobilizing international action against the genocide of the Rohingya. The Gambia's efforts involved, among other things, working with the OIC and its member states to establish and then chair the OIC's ad hoc ministerial committee on accountability for human rights violations against the Rohingya. This does not in any way suggest, as Myanmar tries to argue, that the Gambia's actions, including those done in coordination with or through the OIC and or its ad hoc committee, are not the Gambia's own. Indeed, the Gambia's public statements regarding its efforts to promote accountability for Myanmar's crimes demonstrate that the Gambia itself was taking these actions, and that the Gambia was imploring the international organizations to which it belonged, including especially the UN and the OIC, to further that objective. For example, on the 25th of September 2018, that is over a year before filing the case, the president of the Gambia reported on these efforts to the UN General Assembly. He stated, As the upcoming chair of the next OIC summit, the Gambia has undertaken, through a resolution, to champion an accountability mechanism that would ensure that perpetrators of the terrible crimes against the Rohingya Muslims are brought to book. As you can see, the president of the Gambia was apprising the General Assembly of the Gambia's use of the OIC to seek protection for the Rohingya and accountability for the perpetrators of the crimes committed against them. With respect to its interactions with both the UN and the OIC, the Gambia was acting in its own right and for its own purposes. Moreover, it was the Gambia itself that informed Myanmar by note verbal on the 11th of October 2019 that a dispute exists between the two states regarding Myanmar's violations of the Genocide Convention. You can find it at tab 3 of the Judges folder. The Gambia's note verbal is crystal clear that the Gambia is the party to that dispute. The Gambia stated, "The Republic of the Gambia is deeply troubled by the findings of the UN fact-finding mission regarding the ongoing genocide against the Rohingya people. This has been the case for more than a year, as the record indisputably shows." The Gambia's note verbal further stated that the Gambia considers those findings well supported by the evidence and highly credible, and is disturbed by Myanmar's absolute denial of those findings and a refusal to acknowledge and remedy its responsibility. The Gambia's note verbal also informed Myanmar that the Gambia insists that Myanmar take all necessary actions to comply with these obligations. There can be no confusing the Gambia with the OIC. The same note verbal distinguished between the two when it informed Myanmar that the Gambia fully endorsed a resolution of the OIC calling upon Myanmar to take measures to immediately halt all vestiges and manifestations of the practice of genocide against the Rohingya. Myanmar tries to argue that the Gambia acted on instructions from the OIC. The record shows otherwise. To begin with, it was the Gambia that conceived the idea of bringing a case against Myanmar under the Genocide Convention. As a sovereign state, the Gambia did not need anyone else's instructions or permission to pursue it. The fact that the Gambia sought and received the OIC's support and encouragement is both understandable and immaterial for purposes of this case. It is understandable because for a small state like the Gambia, gaining the political support of the 57 member states of the OIC manifestly increased the influence within the international community that could be brought to bear on Myanmar. It is immaterial because it has no bearing whatsoever on the identity of the applicant in these proceedings. It certainly does not make the OIC the applicant. As the court held in its provisional measures order, the fact that the Gambia may have sought and obtained the support of other states or international organizations in its endeavor to seize the court does not preclude the existence between the parties of a dispute relating to the Genocide Convention. As my colleague, Mr. Suleiman, will explain, there is undoubtedly such a dispute. Accordingly, independently of whether the OIC supported, encouraged, endorsed, proposed, requested, tasked, or whatever else may be Myanmar's preferred word to describe the OIC's relationship to the Gambia's decision to bring the case, the bottom line is this. The Gambia's decision to invoke the court's jurisdiction under Article 9 was the Gambia's decision, no one else's. That decision was undertaken at the highest levels of the Gambian government. In July 2019, a session of the Gambia's cabinet, presided over by His Excellency President Adama Barrow, discussed and approved the proposal for the Gambia's leading legal action against Myanmar at the International Court of Justice. In particular, the official statement of the Office of the Gambia's President records that the Attorney General and Minister of Justice presented a paper on the OIC proposal for the Gambia to lead the international legal action against Myanmar. The statement then memorializes that the Cabinet approved the proposal and also approved the Attorney General's appointment to represent the Gambia throughout the proceedings. To these facts, on Monday, Myanmar could only respond that when the Gambian cabinet decided to bring the case, its announcement of this decision stated that the Gambia would lead the legal action. According to Myanmar, lead is insufficient to establish that the Gambia is the real applicant. So Myanmar's argument comes down to this. The court cannot exercise jurisdiction over a claim under the Genocide Convention because, in Myanmar's estimation, the cabinet of a sovereign state, when taking a sovereign decision for that state to initiate judicial proceedings, used the wrong verb. But even then, to lead the case is not to serve as anyone's puppet or proxy. The fact that the OIC has assisted in organizing political and financial support does not transform the OIC into the applicant or otherwise arrest the case away from the Gambia. The OIC itself has made clear that the case is not the organization's, but the Gambia's. The September 2019 report of the meeting of the OIC's ad hoc ministerial committee, when discussing the OIC's support for the Gambia, acknowledged the Gambia's prerogative to select a legal firm to pursue the case in the ICJ and took note of the Gambia's choice of the legal firm. On Monday, Myanmar asked, does this not suggest that this prerogative was conferred by the OIC? No, it does not. Here, it is Myanmar that uses the wrong verb. Conferred implies that something was given. Acknowledged, which is the word used by the ad hoc committee, constitutes affirmation of a fact or situation that already exists. In this case, it was the Gambia's prerogative as the applicant state to select its own counsel. The court need only consider another part of the same report, which Myanmar elected not to show you. This describes the litigation as the case undertaken by the Gambia. And to this I would add that counsel for the Gambia receive and accept instructions exclusively from the Gambia's agent, no one else. That has remained the case at all times, including in the preparation of the Gambia's application, its memorial, its written observations on Myanmar's preliminary objections, and all of the Gambia's observations on Myanmar's reports under the Provisional Measures Order. Madam President, nothing is changed by the fact that it has sometimes been said that the Gambia brought the case on behalf of the OIC, a description that does not describe a legal relationship, but reflects the fact that the Gambia enjoys the support of the OIC's 56 other member states, who not surprisingly, are also outraged by Myanmar's crimes against their fellow Muslims. In its September 2019 report, the UN fact-finding mission, after concluding that Myanmar was responsible for genocide, welcomed the Gambia's efforts to pursue, in this court, a case against Myanmar under the Genocide Convention. It recommended that the UN and the international community encourage and support such a case. Does this mean that the Gambia brought the case on behalf of the United Nations, or that the UN or its fact-finding mission is the real applicant? Madam President, it could be said, and in fact is often said, that the Gambia brings this case on behalf of the Rohingya. In a sense, it did, because it brought the case to save their very existence. But just as this does not mean that the victims of Myanmar's genocide are the real applicants, neither do the references to the OIC or the UN negate the reality that the Gambia, in law and fact, is the applicant state. The court's jurisdiction, ratione personae, is therefore fully established. Madam President, I turn now to Myanmar's alternative argument that the court should decline to exercise jurisdiction on grounds of admissibility. Here, I can be brief. There are no grounds whatsoever for declining to exercise jurisdiction. There is no indispensable third party. The case does not concern a matter in which the Gambia lacks a legal interest. And, as Mr. Reichler showed, far from being moot or hypothetical, the case and the Provisional Measures Order continue to provide the Rohingya who remain in Myanmar with the court's protection at a time of acute vulnerability. Myanmar knows this, so it argues the case is an abusive process. An abusive process? Myanmar argued on Monday that this is because the Gambia has supposedly brought the case for aims alien to those for which the procedural rights have been granted. But Myanmar did not dare remind you of the actual aims of the procedural rights set out in Article 9. They are, of course, to allow states parties judicial recourse to prevent and punish the crime of genocide. Those are precisely the objectives of this case. This was recognized by the Secretary General of the United Nations, who welcomed the court's order on provisional measures. The Secretary General also cited the case as an example of the appropriate use of peaceful means for the settlement of international disputes. That view is shared by the UN General Assembly, which also welcomed the court's action. And it is shared as well by the Office of the UN High Commissioner for Human Rights, which described the proceedings before the court as being vitally important. Madam President, these facts lead to only one conclusion. The Gambia is the applicant. There is no basis to strip it of that role or to deny its right to bring this case as a sovereign state that is a party both to the statute of the court and the Genocide Convention. There is no merit whatsoever to Myanmar's first preliminary objection, and it must be rejected, as it was in the court's January 2020 order. Madam President, members of the court, this concludes my presentation. Thank you very much for your kind attention. I ask that you invite Professor Darjan to the podium to address Myanmar's second preliminary objection.
I thank Mr. Lowenstein. And I now invite Professor Pierre Dargent to address the court. You have the floor, Professor.
Thank you, Madam President. Madam President, members of the court, it is always an honor to speak before this court, and it is so again as I speak to support the Gambia. According to Myanmar's second preliminary objection, the Gambia's application is inadmissible due to the Gambia's lack of standing to take action in this case. Just like the other preliminary objections of Myanmar, this second objection had already been raised during the provisional measures stage. However, what is new since Monday's hearing is the reason given by Myanmar to support this objection. I would like to address this point in the first part of my pleading. I will then address the issue of common interest that characterizes the ergo omnes partes obligations and its significance with respect to the present case. In the third part of my presentation, I will come back to the question of standing to take action per se. And I will conclude in the fourth part by briefly examining Article 9 of the Convention, given what Myanmar has said about it in its written pleadings regarding the Gambia's standing to take action. Madam President, during the December 2019 hearings, Myanmar did not challenge the Gambia's right to invoke its international responsibility. This court's order of January 2020 states clearly, and I quote, Myanmar accepts that because of the erga omnes partes character of some obligations under the Convention, the Gambia has an interest in Myanmar's compliance with such obligations. End of quote. Myanmar thus accepted that the Gambia could indeed invoke its international responsibility. However, Myanmar challenged the Gambia's standing to take action before the court. That is to say, to bring this dispute arising from this invocation before the court. This is what has led to the rather absurd dead end according to which the dispute could indeed arise and exist following the invocation of Myanmar's responsibility, but it was not likely to be brought before the court for judgment. Whatever be the case, during the provisional measures stage and also in its written submissions supporting its preliminary objections, Myanmar argues that the Gambia did not have standing to take action before the court because Article 9 of the Convention excluded any actio popularis. As I mentioned at the outset, I will come back to this point at the end of my pleading. But since then, Myanmar has changed governments and councils and has modified its legal arguments. It now argues that the Gambia doesn't even have standing to invoke Myanmar's international responsibility. And why is that so? Because the Rohingyas, who are persecuted and killed by Myanmar, don't have Gambian citizenship. Yes, members of the court, you heard me right. Apparently, the Gambia cannot invoke Myanmar's responsibility and therefore would not have standing to bring the present dispute before the court because the victims of the clearance operations conducted by the Tatmadaw don't have Gambian nationality. If it weren't so tragic, I would be tempted to be ironical and remind Professor Talman that the Rohingya, that he obstinately refuses to call by their name, that the Rohingya did not have Burmese citizenship either, precisely because they had been stripped of their citizenship due to the law enacted in 1982. However, I would prefer to quote the exact words that he used on Monday. He said, and I quote, the nationality of claims rule applies to the invocation of responsibility by both injured and non-injured states, and irrespective of whether the obligations breached is an erga omnes partes or erga omnes obligation. Under the law of state responsibility, the Gambia cannot invoke the responsibility of Myanmar for violations of the Genocide Convention with regard to individuals who are not its nationals. Madam President, it doesn't take much reflection to realize how absurd or even abject this legal theory is when applied to the Genocide Convention. If we were to follow Myanmar's reasoning, no state party to the Convention would have the right to invoke the responsibility of another state party as long as the latter meticulously implements its genocidal project exclusively on its own nationals. We all know, however, that genocide generally begins within a country, and that most often it targets the nationals of the genocidal state itself, a group that forms a certain ethnic, racial and religious group. Very often, as is the case with the Rohingya, the members of the group being targeted can be identified because they're deprived of the nationality of the country where they live and who persecutes them, whereas they're not the nationals of any other country. Can we seriously agree, members of the court, can we seriously agree that it is in conformity with the Convention's object and purpose to refuse in such a case that any other state has standing to invoke the responsibility of the state that is the perpetrator of genocidal violence? I would like to emphasize that the consequence of Professor Talman's theory would be not only to make it impossible to invoke the responsibility of the state committing genocide against the members of a group having its own nationality, but it would also protect a genocidal state from any similar invocation, even when this state targets members of a group having the nationality of one or several third state parties to the Convention. In that case, indeed, no state party would be able to take action either, unless the victims had the nationality of one of them. Madam President, members of the court, not only is the theory that Myanmar presented on Monday absurd, abject, and completely contrary to the object and purpose of the Convention, it is also erroneous with regard to the legal principles on which it is purportedly based. What does Article 44A of the Article on International Responsibility of States say? This is the article on which Myanmar has based its arguments. It says, and I quote, "The responsibility of a state may not be invoked if the claim is not brought in accordance with any applicable rule relating to the nationality of claims." End of quote. This provision does not give any indication that there might be a nationality of claims rule which would apply, broadly speaking, to any interstate claim. No, this is not what the provision says. This provision only recalls that when the rules in terms of nationality of claims apply, the invocation of responsibility of a state by another state is subject to these rules. When paraphrasing Article 44, the commentary of the International Law Commission, to which Professor Talman, in fact, referred, explains that the nationality of claims rule is a general condition for the invocation of responsibility in cases when it is applicable. The Gambia argues that in the case of the Genocide Convention, such a rule is obviously not applicable. Indeed, the nationality of claims rule is not applicable because nothing in the Convention's text suggests that it would be the case, particularly because, as I just explained, it would be contrary to the object and purpose of the Convention to make claims of state parties conditional on this rule. Need I remind the Court that according to Resolution 96-1, genocide is contrary to the spirit and aims of the United Nations, that it shocks the conscience of mankind by resulting in great losses to humanity through the total or partial destruction of a national, ethnic, racial, or religious group, regardless of the nationality or absence of nationality of the members of this group. What would happen to this essential and universal ratio legis that your order indicating provisional measures recalled if Myanmar's argument were to be accepted? Myanmar has made no reference to the object and purpose of the Convention when it argued that the nationality of claims rule was applicable to it. This silence is indeed eloquent, and Myanmar's about-face on the issue that it was purportedly impossible for the Gambia to invoke its international responsibility is not only misguided, but also baseless. In reality, and as Myanmar accepted in December 2019, but no longer seems to accept, it is indeed in the Gambia's interest that Myanmar fulfills its obligations, and this interest exists under Convention due to the erga omnes partes nature of its obligations. Madam President, members of the Court, Myanmar does not challenge the erga omnes partes nature of the obligation of the Convention, which is at the heart of the present dispute. Without going to the details of your jurisprudence, which is well established in this regard and that you recalled in your order of January 2020, Myanmar is nonetheless attempting to minimize its scope by arguing that a common interest, the existence of a common interest with respect to compliance with the Convention would not constitute an individual legal interest, to use Professor Talman's words, an individual legal interest intended to be enforceable before the Court, that the Court's jurisprudence, according to Myanmar, has never accepted this rule as such, and that in reality, according to Myanmar again, the Court has even cast a doubt on this rule in the Bosnia versus Serbia case. And yet, since the 1951 advisory opinion, this Court's jurisprudence tells us that in a convention such as the Genocide Convention, and I quote, the contracting states do not have any interests of their own. End of quote. Myanmar is attempting to look for something in your jurisprudence that the Court has excluded over 70 years ago. When it concerns the Genocide Convention, there is no question of individual legal interest, and as the advisory opinion has already indicated, common interest of contracting parties belongs to one and all. However, this in no way implies that each state party would be deprived of an interest to comply with the Convention. Quite the opposite, actually. When a state party invokes the responsibility of another state that is bound by the Convention, it does indeed have an interest in doing so. However, its interest is not specific to the state itself. Its interest, which is shared by all other parties, is the interest in making sure that the common interest of prevention and repressing genocide is fully protected. As you have emphasized in your order of January 20, and I quote, that common interest implies that the obligations in question are owed by any state party to all the other state parties to the Convention. End of quote. That is to say, to one and all. The court has inferred in paragraph 41 of its order, and I quote, that any state party to the Genocide Convention, and not only a specially affected state, may invoke the responsibility of another state party with a view to ascertaining the alleged failure to comply with its obligations, erga omnes partes, and to bring that failure to an end.
Now, Professor Tallman has somewhat challenged your ruling and has invited you to reconsider it. According to him, a careful rethink would be necessary because you won't have had the benefit of an adversary debate as the court gave its ruling at the provisional measures stage. Now, it's true that Professor Tallman was not the counsel of Myanmar at the time, and that the arguments which he developed were not worded by or formed by Myanmar at the time. But I can restrict him, reassure him that the principle of an adversary hearing was guaranteed at all stages of the proceedings by the court, and indeed it was done so in December 2019. Indeed, it's erroneous to claim that paragraph 41 of your order only concerns the right of invoking responsibility and not standing. Indeed, this paragraph ends the second part of the order, whose title covers exactly the question of the standing of the Gambia. Professor Tallman adds that paragraph 41 of your order does not take into account the requirements of the rule about the nationality of claims, but I've already explained that this rule was not applicable to the claims between states party to the Genocide Convention. Paragraph 91 of the judgment in the Barcelona traction case, which was raised by Professor Tallman, also does not challenge this conclusion, because the court compares universal instruments for human rights concerning the denial of justice to the European Convention of Human Rights. So there is no mention, or it's not at all a question in this paragraph, of the Genocide Convention. Myanmar has further claimed that the judgment of Belgium versus Senegal would also be no assistance to the Gambia because the court did not need to examine in that case whether the nationality of claims limited the status of Belgium or the standing of Belgium to pursue the case. As an applicant state, Belgium had simply restricted itself to invoking the responsibility of Senegal to a breach of a repressive nature of its obligations. Nonetheless, this 2012 judgment did clearly underscore that as regards erga omnes partes obligations, if a special interest were required, then so as to be able to make a claim concerning the succession of an alleged breach by another state's party, then in a lot of cases, no state would be in a position to make such a claim, full stop. So Myanmar is seeking precisely to obtain what the court tried to avoid by the 2012 judgment. Myanmar has also raised the question of the 2007 judgment in the Bosnia versus Serbia case to support its theory about the nationality of claims. But what did the court decide in that case? Well, that it didn't have to settle the question as to whether the nationality of claims limited the right of Bosnia to advance claims for acts inflicted on non-Bosnians outside its territory, lacking evidence to this respect. For the rest, the court simply said that insofar as that request might relate to non-Bosnians victims, it could raise questions about the legal interest or the standing of the applicant as regards such matters, and the significance of the jus cogens character of the relevant norms and the erga omnes character of the relevant obligations. What then should we note in this sentence? Well, that legal interest and standing are put on an equal footing, and that both necessarily depend on the erga omnes character of the obligations under the Convention and the peremptory nature of its norms. The Gambia does not say anything different, and the court reiterated or recalled in its 2020 judgment or order that the obligations of the Convention are indeed erga omnes partes. Madam President, distinguished members of the Court, the Gambia also has standing to invoke the responsibility of Myanmar and standing to bring this case before you. The Gambia has recognized that this last question is raised whenever the basis for jurisdiction is used, and the Gambia also accepts that it is a general exception, a demand to contentious cases before the court. Now, what actually is standing? Since the Wimbledon case, standing has been nothing else than the interest for the respect of the rules that are at the heart of a given dispute. In other words, the interest that a party has in a dispute to see this dispute settled according to the rules. If this interest exists, then standing is established. In the case of a bilateral obligation, standing derives from the practical and particular interest pursued by the legal action. But when the obligations which should be applied to solve the dispute are erga omnes partes, then it is the opposite that is true. It is then the identity of a party to the instrument bearing these obligations that establishes the act and the interest in acting. This is the same for all states to a party to a convention, because each have, to echo your words, a common interest in ensuring that their acts of genocide are prevented and that if they occur, their authors do not enjoy impunity. As the Court has already underscored, the specific nature of erga omnes partes obligations is due to the fact that each state party has an interest in compliance with them in any given case. Now, these words are opposed in any given case are opposed to those of in a specific case. Professor and later Judge Giorgio Gaia particularly stressed this specific nature of erga omnes obligations in his report to the Institut du Droit International. It is because it is the circumstances particular to each case do not have any bearing on the interest of any state in seeing these obligations respected that these obligations are of an erga omnes partes character. Consequently, any non-directly injured state also has a necessary interest to invoke the responsibility of a state accused of a breach of these obligations. When this invocation ends up in a dispute, as is in the case in the present proceedings, then Article 9 of the Convention opens the way for the Court to whichever of the parties to this dispute wishes to seize it. If the seizing of the Court is by a non-injured party to the dispute, then its standing is due to its interest, which it has in common with other states parties to the Convention, to seeing it respected. It brings me to the last section of my pleadings, distinguished members of the bench. Madam President, distinguished members of the bench, Article 9 is a compromissory clause which is particularly clear and non-ambiguous. As your order of January 2020, as recalled, Article 9 governs two things. First of all, your jurisdiction and your seizing. Now, you know Article 9 rather well, and I shall not read it. I'll just project it on the screen as a reminder. Under Article 9, your jurisdiction extends to those disputes arising between parties to the Convention on the subject of obligations set out in that Convention without any prior procedural condition and without any limitation being binding upon the states parties to these disputes, if it's not for the fact that, of course, they have to be bound by the Convention. Of course, therefore, Article 9 indicates that such disputes can be submitted to the Court for settlement by one of the parties to the dispute and not by one of the parties to the Convention who is not a party to the dispute. As I've said, that's perfectly clear. Nonetheless, in his written submissions to support preliminary objections by Myanmar, Myanmar has claimed mainly that the Gambia lacks standing because Article 9 of the Convention is alleged to exclude any kind of actio popularis. In fact, under cover of an alleged lack of standing, Myanmar is in fact raising an objection of a lack of jurisdiction because it is advancing that Article 9 of the Convention will not allow the court to rule on a request submitted by a state party when the latter is not directly or personally injured by the actions that it is denouncing. According to Myanmar, the action popularis would therefore be materially excluded by Article 9 in such a way that the consent given to your jurisdiction by this article will not cover this kind of action. To support this theory, Myanmar, in its written submissions, concocts specious arguments concerning words lacking in Article 9 or differences between Article 8 and 9, whereas these provisions actually have completely different aims. A key point in the argument advanced by Myanmar, which I won't repeat in toto, is that Article 9 concerns not all disputes or any disputes, but just disputes. Now, you've heard virtually nothing on this subject on Monday, as Professor Kolb was the only one who vaguely referred to this argument when he contrasted Article 9 with Article 24 of the European Convention of Human Rights. Even if Myanmar has probably noted the weakness of its written arguments and has generally abandoned them on this point, I wish nonetheless to recall that Article 9 starts with the words disputes. Disputes in English, in plural, and in an undetermined and therefore inclusive manner. This provision requires disputes at issue between the parties do actually exist and that they should be relating to the interpretation, application or fulfillment of the present convention, which includes disputes, and I quote again, relating to the responsibility of a state for genocide or any other act enumerated in Article 3. So, in other words, it's enough for a dispute to exist, for a party to that dispute to bring it before the court, and for these providing, of course, that these two parties are both bound by Article 9. So the ordinary meaning of the words used in Article 9 leaves no doubt. No distinction is drawn between possible disputes as arising from the obligations of the Convention or between contracting states which are parties to these disputes, whether they are or not directly injured. The interpretation of Article 9 proposed by Myanmar is not only contrary to the ordinary meaning of the words which are used and to their context, but it also runs up again against the aim and purpose of the Convention. Despite the clarity of Article 9, Myanmar still asserts in its written pleadings that the tortuous interpretation that it proposes is allegedly confirmed by the travaux préparatoires of the Convention. Now, our written submissions have fully replied to the partial reading of the travaux developed by Myanmar, and I would remind you to refer to them, in particular as Myanmar has not said anything about it on Monday. But just so as to be exhaustive on Article 9, I will add that you have been seized by the Gambia of the dispute between it and Myanmar. This seizing is not due to another state which is bound by the Convention, which is not party to this dispute. The fundamental conditions, therefore, of Article 9 are all satisfied. Madam President, distinguished members of the Court, for the reasons that I've just expounded, and also for those developed and advanced in our written submissions, this second objectional preliminary opinion objection by Myanmar should be rejected. I would like to thank you for your kind attention, and suggest that you would give the floor to Mrs. Paso-Dia, perhaps after the break.
Of 10 minutes. The sitting is adjourned.
Who are the Rohingya? The Rohingya are an ethnic group, the majority of whom are Muslim, who have lived for centuries in the majority Buddhist Burma. Currently, there are about 1.1 million Rohingya residing in their homeland, Arakan. Nearly all of the Rohingya in Burma live in the western coastal state of Arakan, formerly known as Rakhine, and are not allowed to leave without government permission. It is one of the highly resourceful states which has been kept as a poorest state in the country, with ghetto-like camps and a lack of basic human rights, services and opportunities. Shortly after Myanmar's independence from the British in 1948, the Union Citizenship Act was passed defining which ethnicities could gain citizenship. Rohingya were initially given such identification or even citizenship under the generational provision. During this time, several Rohingya also served in parliament. After the 1962 military coup in Burma, things changed dramatically for the Rohingya. All citizens were required to obtain national registration cards. The Rohingya, however, were only given foreign identity cards, which limited the jobs and educational opportunities they could pursue. Although Rohingya were denied from ethnicity, the act, however, did allow those whose families had lived in Burma for at least 2 generations to apply for identity cards. Since then, they are not considered one of the country's 135 official ethnic groups and have been denied citizenship since 1982, which has effectively rendered them stateless. As a result of the law, their rights to study, work, travel, marry, practice their religion, and access health services have been and continue to be restricted. The Rohingya cannot vote, and even if they navigate the citizenship test, they must identify as naturalized as opposed to Rohingya, and limits are placed on them entering certain professions such as medicine or law or running for office. Due to ongoing violence, systematic persecution and genocide from over the past 70 years, nearly 3 million Rohingya have fled to neighboring countries either by land or boat over the course of many decades, such as Bangladesh, India, Pakistan, Malaysia, Thailand, Indonesia, Saudi Arabia, and many more. The persecution of Rohingya continues for many decades till the present day and became the world's most persecuted minority. Where are the Rohingya from? The ancestry of Rohingya has long been a topic of confusion among diaspora, as well Rohingya within themselves, especially among the new generations. In order to break down Rohingya's ancestry, let's look into today's topic. The most commonly heard myth tells of a ship of Arab traders that arrived at the shores of Ramri Island in the 18th century and wrecked off the Burmese coast, and the survivors asked for ram of the local king. The king allotted a piece of land for them and they were allowed to settle there. Over time, Ram changed to Rohang and eventually to Rohingya. The first sign of the Muslim settlement was found in 788 to 810 CE. Documentary evidence shows that the early Arab had contact with Arkan and Bengal. During the colonial period, Muslims in Arkan were referred to in many different ways: Muslims, Mohammedan, Chittagonians, Rohingya, Rosawan, and many more. In 1799, Francis Buchanan, a Scottish surgeon with the British East India Company, traveled to Burma and met members of a Muslim ethnic group who have long settled in Arkan and called themselves Rohingya. Muslim leaders in Rakhine State have promoted the use of the term Rohingya to describe themselves as part of their assertion of rights along ethnic lines. The first formal acknowledgement of the ethnonym Rohingya dates to 10 March 1950 in an official address by a group of elders from North Arkan to Prime Minister Unu on his visit to Mangda. Michael W. Charney states that the derivation of Rohingya from Rohingya is very clear. Rohingya can be traced to the 17th century to Rosanga. Although the language of Rohingya was widespread during the era of Arkan kings, today its existence as a written language has diminished, as it was mainly destroyed by the Burman invaders in 1784 and was not preserved well by subsequent colonialists. Arkan was an independent state until it was invaded by Burman king Boda Peya in 1784 and annexed to the Burman kingdom. It is believed that the Muslims first reached Arkan in the 8th century and through a gradual process of expansion in the 15th and 16th centuries, a distinct Arkanese Muslim community was formed. Some believe that they are descendants of Moorish, Arab, and Persian traders who had arrived and settled in Arkan between the 9th and 15th centuries. Migrants arriving from Persia, Turkey, northern India, and the Arabian Peninsula were later added to these settlers that create a distinct dialect which is a mix of Persian, Urdu, Arkanese, and Bengali. During the 12th and 13th centuries, larger groups arrived in Arkan and rapidly integrated as well. The second wave of Muslim immigration into Arkan began in the 15th century and lasted until 1784, when the Burmese king Boda Peya conquered Arkan. In the 17th century, Arkan reached its peak of glory through the contribution of Muslim poets, Muslim learned men, saints, and administrators. Meanwhile, historical scholars and natives claim that the population is indigenous to the Arakan state since the 19th century when the nation was under British occupancy. But though Rohingya had lived in Arakan for centuries, and though Britain promised the Rohingya an autonomous state in exchange for their help in World War II, it never followed through. After the end of the war, Burma gained its independence from Britain in 1948. The government didn't provide for a Muslim state either, nor did it acknowledge the Rohingya. Instead, Burma worked to cast out the Rohingya people, excluding them from its constitution. In 1982, Burma passed a citizenship law that denied the Rohingya people citizenship too. Until today, Rohingya are in continuous limbo and their tales of woes, persecutions, and genocide echoes around the world. Azadi TV'র কিছু মাসের কামিয়াবিত ইদ্দুর সফরত সাথ দিয়াত হার সাবস্ক্রাইবার অক্কলরে বেশি শুক্রিয়া জানার আর মম্মিকায় আরারে ইন্দিলা সাথ আর মদত অক্কল গরিবলা আরার ফুয়াতি তাই বলা আরজ গরা যার আর তোয়ারা তো আরার হামরো ফসল লাগি মদত করতে চাইলে তোয়ারা হাসাত তো আছে দে জয়েন্ট বাটন সিবিওরা আরারে মদত গরি ফারিবা।
আমার আদো যার কান তুই আর ফরান আর ফরান আমার আদো যার কান তুই আর ফরান আর ফরান তুই সারা খন জাগাত তুই সারা খন জাগাত শরীর নজুর আর আরকান আমার আদো যার কান তুই আর ফরান আর ফরান আমার সুন্দর যার কান তুই আর ফরান আর ফরান চাঁদ সিতারার মতন সুন্দর সোনালি আর কানর শহর চাঁদ সিতারার মতন সুন্দর সোনালি আর কানর শহর তোরে যদি চাইলে খেয়াল আইতো জন্নতর বাগান আমার আদো যার কান তুই আর ফরান আর ফরান আমার আদো যার কান তুই আর ফরান আর ফরান তুই সারা খন জাগাত শরীর নজুর আর আরকান আমার আদো যার কান তুই আর ফরান আর ফরান রাই তোর আন্দার ওইলে তোর বাগানত ফুল ফুটে পানে ওইতো রাই তোর আন্দার ওইলে তোর বাগানত ফুল ফুটে পানে ওইতো হতো সুন্দর জুনাই ক্যা ফুক হতো সুন্দর জুনাই ক্যা ফুক লাগর দেহ মোর ফান ফান আমার আদো যার কান তুই আর ফরান আর ফরান আমার আদো যার কান তুই আর ফরান আর ফরান দিল ফেরেশান ওইলে মন্তর তোর মুরাদ যাই বেড়াইতাম দিল ফেরেশান ওইলে মন্তর তোর মুরাদ যাই বেড়াইতাম হিরির বইয়ার হাই হাই হিরির বইয়ার হাই হাই টান্ডা গইতাম শরীর গান আমার আদো যার কান তুই আর ফরান আর ফরান তুই সারা খন জাগাত শরীর নজুর আর আরকান আমার আদো যার কান তুই আর ফরান আর ফরান আমার সৌন্দর্য আর কান তুই আর ফরান আর ফরান জাগা জাগা বেড়াই বেড়াই মঞ্জর সাইতাম ওতনর জাগা জাগা বেড়াই বেড়াই মঞ্জর সাইতাম ওতনর সে হতা উড়িলে মনত ফাড়ি যাইতো সার নইয়ান আমার আদজ্জা আর কান তুই আর ফরান আর ফরান আমার আদজ্জা আর কান তুই আর ফরান আর ফরান তুই
Please be seated. The sitting is resumed. I now give the floor to Ms. Tafadzwa Pasapanodia. You have the floor, Madam.
Madam President, members of the court, it is a privilege to appear before you again on behalf of the Gambia in its efforts to hold Myanmar to account for the genocide of the Rohingya people. In Myanmar's third objection, it argues that the Gambia's application is inadmissible because, I quote, "The Gambia, as a non-injured contracting party to the Genocide Convention, may not seize the court with a case arising under the Convention, since Myanmar, when acceding to the Convention, has entered a reservation to its Article 8. End quote. Struggling for a way to extend its reservation to Article 8 of the Convention to Article 9, an article to which it has no reservation, Myanmar argues that the Gambia's ability to seize the court to resolve its dispute with Myanmar under Article 9 is somehow governed by Article 8. Article 8, however, is irrelevant to the session of the court. The court made this clear in its order of 23 January 2020 when it rejected Myanmar's objection on a prima facie basis. It ruled that
How do I get the question?
of the court. There have been no changes to Article 8 or Article 9 since the court issued its order a little over 2 years ago. There are no new facts that could cause the court to reach a different interpretation of these articles. Myanmar itself offers nothing new. Instead, it asks the court to reverse its determination on the basis of a purportedly in-depth analysis. But Myanmar has not been able to present a single authority of any sort to support its peculiar view that Article 8 governs the session of the court to hear a dispute between contracting parties under Article 9. As explained in the Gambia's written observations, and as I will recall briefly today, the terms of Article 8, its object and purpose, as well as the preparatory works of the Convention, demonstrate that Article 8 governs appeals to UN organs at a political level. It has no bearing on the session of the court to resolve a legal dispute between state parties. I begin with the ordinary meaning of the terms of Article 8. Madam President, as you can see in the screen before you, Article 8 provides, "Any contracting party may call upon the competent organs of the United Nations to take such action under the Charter of the United Nations as they consider appropriate for the prevention and suppression of acts of genocide or any of the other acts enumerated in Article 3. Upon Myanmar's accession to the Genocide Convention, it entered a reservation to Article 8, stating, with reference to Article 8, the Union of Burma makes the reservation that the said article shall not apply to the Union." Myanmar argues again, as it did at the hearing on the provisional measures, that the wording of Article 8 indicates that it is Article 8, rather than Article 9, that enables a non-injured contracting party to the convention to seize the court to resolve a dispute with another contracting party. The primary basis of Myanmar's argument is that the court is one of the quote-unquote competent organs of the United Nations. But as the court explained in its order of 23 January 2020, although the terms competent organs of the United Nations under Article 8 are broad and may be interpreted as encompassing the court within their application, other terms used in Article 8 suggest a different interpretation. In particular, the court noted that Article 8 only addresses in general terms the possibility for any contracting party to call upon the competent organs of the United Nations to take action which is appropriate for the prevention and suppression of genocide. As the court continued, Article 8 does not refer to the submission of disputes between contracting parties to the Genocide Convention to the court for adjudication, which is a matter specifically addressed in Article 9 of the Convention. Indeed, as the Gambia explained in its written observations, the court as a judicial institution does not take actions under the United Nations Charter. Rather, in exercising jurisdiction in contentious cases, the court renders legal judgments in accordance with Article 38(1) of the statute. Nor are the judgments based on what it considers appropriate, as Article 8 requires. Such judgments are rendered solely on the basis of international law. The court may only decide a case ex aequo bono if the parties agree thereto. The conclusion that Article 8 does not address the seisin of the court is further confirmed by its use of the words call upon to describe the contracting party's engagement with the competent organs of the United Nations. These words are employed in connection with appeals to the exercise of discretion. The Oxford English Dictionary defines call upon as meaning to appeal to a person, organization, etc., to do something, to require, urge, or demand that a person, organization, etc., do something. Call upon is not a formulation that ordinarily describes the initiation of judicial proceedings, and even Myanmar does not attempt to suggest otherwise. Instead, Myanmar invites the tribunal to consider the French and Spanish versions of the Genocide Convention, which use saisir and recourir respectively for the term call upon. The argument fares no better in these languages. Both terms are also commonly used to refer to appeals to political and security authorities, as reflected in the definitions of the terms that Myanmar itself submitted before the court. Madam President, the ordinary meaning of the terms of Article 8 simply do not permit the reading that the article seeks to govern the seisin of the court in a dispute between two contracting parties. Neither do the object nor purpose of Article 8 offer assistance to Myanmar. Myanmar contends that Article 8 must be understood as regulating the right of a non-injured contracting party to bring a case to the court. Otherwise, Article 8 would be devoid of any meaningful object and purpose. But as Judge Gaia explained in his commentary, Article 8 could be construed as implying that all the contracting states accept that a matter referred to under Article 8 of the Convention does not pertain to domestic jurisdiction, and therefore, as removing the barrier raised by Article 2(7) of the UN Charter to UN Security Council engagement. In fact, Myanmar's parliamentary discussions upon ratifying the Genocide Convention demonstrate that its Article 8 reservation was motivated precisely by a concern about this sort of interference with its domestic jurisdiction. Myanmar explained that it entered reservations to Article 8 and Article 7, which preserves the rights of domestic courts to hear cases of genocide, because of its belief that, I quote, "What happens internally in a country concerns the people of that country, and outside interference is undesirable for what happens internally in a state party." End quote. Significantly, at that time, Myanmar confirmed that except for Articles 8 and Article 7 of the Convention, it supported all the other ones. The words "all the other ones" encompass Article 9. I come to the third and final point of my submission, Madam President. The Genocide Convention's preparatory works confirm that Article 8 is unrelated to the season of the court under Article 9. You heard Professor Kolb inform you on Monday that the travaux préparatoires of the Genocide Convention confirm that Article 8 governs all principal UN organs, including the court. He omitted, however, discussion of any of this preparatory work, because doing so would show quite the opposite. Article 8 was only intended to govern the political organs of the United Nations and not the court, which was addressed in Article 9. Right from the outset of the drafting procedure, Article 8 and Article 9 were envisioned as addressing distinct matters. In the 1947 draft text of the Convention, prepared by the UN Secretariat, engagement of the UN's organs was addressed in draft Article 12, the forerunner of what would become Article 8, which was entitled Action by the United Nations to Prevent or Stop Genocide. Significantly, the drafters elected to locate the compromissory clause in a different part of the Convention, then Article 14, which bore the title Settlement of Disputes on Interpretation or Application of the Convention. The report of the Ad Hoc Committee records that draft Article 8 was discussed at length when the committee considered questions of principle, and again when the articles of the Convention were being drafted. Yet there is no evidence that any of the participants ever suggested that Article 8 should govern the season of the court. As Professor Kolb himself recognized on Monday, it would normally be, quote unquote, absurd to consider that a compromissory clause such as Article 9 would govern the competence of the court, but not its season. Surely then, the drafter's decision to adopt the absurd approach of placing the season of the court in a separate article from that containing the compromissory clause would have warranted some discussion during the drafting negotiations. But none is evident, nor is there any indication that the participants intended to establish different obligations for contracting parties to seize the court depending on the extent to which they were injured by genocidal acts. The text of Article 8 made no distinction between the ability of injured and non-injured contracting parties to appeal to the UN organs. And evidently, the drafters saw no reason to consider, let alone adopt, such a distinction. Instead, the debate on Article 8 centered on whether the article should refer specifically to the Security Council, or instead not mention any specific political UN organ. Those advocating the latter view argued that although the Security Council appeared to be the organ to which governments would most frequently wish to apply, it was undesirable to rule out the General Assembly, the Economic and Social Council, or the Trusteeship Council. In some cases, it would be of advantage to call on the General Assembly, because it directly expressed the opinion of all the members of the United Nations, and because its decisions were taken by a majority vote, with no risk of the right of veto preventing a decision. As is clear, the drafters only addressed political organs in their consideration of the scope of Article 8. The General Assembly, the Economic and Social Council, and the Trusteeship Council. There was no mention whatsoever of the court. The preparatory works show that later in the drafting process, the Sixth Committee decided to delete Article 8 by a small majority on the basis of a joint amendment by Belgium and the United Kingdom, suggesting that the article did not expand the powers of the UN organs. It was pursuant to an Australian amendment to Article 9 that Article 8 was reinstated at a subsequent meeting. The reasoning for the Australian amendment confirms that Article 8 was intended to address appeals to the political organs of the United Nations, rather than the court, because recourse to the court had already been established in Article 9, then number 10. As recorded in the Sixth Committee, the Australian delegation considered that a clause should be inserted in Article 10 concerning organs of the United Nations other than the International Court of Justice, which could take useful action in suppressing genocide. The purpose of reinserting Article 8 in the draft convention was therefore precisely to allow recourse to the political organs of the United Nations as distinguished from the court. The United Kingdom's explanation for voting for the adoption of Article 8, after having initially proposed its removal, further confirms that the article was intended to ensure recourse to the UN's political organs. The UK delegate explained that although his delegation considered it unnecessary to include in the convention provisions conferring on the organs of the United Nations powers that they already possessed under the terms of the Charter, it had voted in favour of the Australian amendment reinstating Article 8 in order that it may be clear, beyond any doubt, that his prior amendment proposing the deletion of Article 8 did not imply that recourse might be had only to the International Court of Justice, to the exclusion of the other competent organs of the United Nations. The drafting history of the Convention is thus clear about the allocation of respective functions of Articles 8 and 9. The former concerns access to the UN's political organs, the latter to the court. This is consistent with the court's holding in its 2007 judgment in the Bosnian genocide case that Article 8 may be seen as completing the system of the Genocide Convention by supporting both prevention and suppression, in this case at the political level, rather than as a matter of legal responsibility. Commentators on Article 8 have also concluded that Article 8 refers only to the UN's political organs. Dr. Schiffbauer, for example, explains in his commentary on Article 8 that, in contrast with the initiation of strictly judicial proceedings before the ICJ, which is governed by the ICJ statute, referral to UN organs is a much more amorphous concept. Referral under Article 8 can be seen as a more political procedure, which serves as an alternative weapon in achieving the prevention and the punishment of the crime of genocide. We refer to Dr. Schiffbauer's commentary in particular because Myanmar, in its written pleading, expressly relies on that commentary for the proposition that Article 8 must not be deprived of its meaningful object and purpose. But Myanmar neglected to mention that Dr. Schiffbauer wrote that referral under Article 8 can be seen as a more political procedure, and that it stood in contrast with the initiation of strictly judicial proceedings before the ICJ, which is covered by Article 9. Nor does Myanmar mention Dr. Schiffbauer's conclusion that contradicts Myanmar's foundational argument that Article 8 governs the session of the court in disputes concerning contracting parties. Consistent with the ordinary meaning of the terms of Article 8, interpreted in context and in light of its object and purpose, Dr. Schiffbauer concludes, Article 8 does not add to nor diminish from the court's competencies as defined by Article 9. For the scope of the court's competencies, it is irrelevant. Dr. Schiffbauer is not alone. Professor Kolb himself wrote in 2009 that session of the court by a party to a dispute under the Convention is governed by Article 9, not Article 8. In striking contrast with his insistence before you on Monday that Article 8 governs the session of the court and is therefore indispensable for the court's session in the present dispute, in his commentary on the Genocide Convention before he was retained by Myanmar, Professor Kolb was unequivocal that Article 9 allows a unilateral seizing of the ICJ by any party to a dispute. Professor Kolb continued, moreover, it must be noticed that the compromissory clause in Article 9 of the Genocide Convention contains no further limitations, for example, as to previous negotiations. Such restrictive conditions may prompt delicate problems, all of which are avoided in the Genocide Convention. Article 9 of the Genocide is in this respect a model of clarity and simplicity, opening the seizing of the court as largely as possible. Madam President, members of the court, for all of these reasons and those set out in the Gambia's written observations, the court should once again reject Myanmar's third preliminary objection. I thank you for your courteous attention and ask that you call my colleague, Mr. Arsalan Suleiman, to address Myanmar's fourth preliminary objection.
I thank Ms. Pasapanoja, and I now invite Mr. Arsalan Suleiman to address the court. You have the floor.
Madam President, members of the court, it is an honor to address the court, and especially to do so again today as counsel for the Gambia. In its fourth preliminary objection, Myanmar argues that the court lacks jurisdiction, or alternatively, that the application is inadmissible because there was no dispute between the Gambia and Myanmar at the time of the filing of the application. This objection, like the others, is entirely without merit. My presentation is organized in three parts. First, I briefly recall the court's standards for determining the existence of a dispute. Second, I recount the clear factual bases that establish the existence of a dispute between the Gambia and Myanmar prior to the filing of the application. And third, I identify the various ways in which Myanmar's new standards for determining the existence of a dispute would not only run contrary to the court's jurisprudence, but would also functionally give respondent states a veto over the court's exercise of jurisdiction and graft onto the Genocide Convention a new negotiations requirement. The court's standards for establishing the existence of a dispute are well known. Indeed, the court set them out in its order of 23 January 2020 on provisional measures, so I need not dwell long on them. The court has made clear that a dispute between states exists where they hold clearly opposite views concerning the question of the performance or non-performance of certain international obligations. Also, a dispute exists when it is demonstrated on the basis of the evidence that the respondent was aware or could not have been unaware that its views were positively opposed by the applicant. The disagreement on a point of law or fact, a conflict of legal views or interests, or the positive opposition of the claim by one party by the other can be established expressly or by inference. The court's use of the disjunctive or in this recitation of the pertinent standards makes clear that any one of those showings would establish the existence of a dispute. And a dispute can also be inferred from the respondent's failure to respond in circumstances where a response is called for. The court takes into account exchanges between the parties in bilateral and multilateral settings, and the exchanges should refer to the subject matter of the dispute with sufficient clarity. These are the proper standards to be applied when the court determines the existence of a dispute, and they are amply met by the facts in this case. On Monday, Mr. Staker outlined 4 requirements that Myanmar asserts are necessary to establish a dispute. But as discussed further below, these do not track with the court's settled jurisprudence. Madam President, both the parties' exchanges at the United Nations and the Gambia's note verbal of 11 October 2019 clearly demonstrate the existence of a dispute between the Gambia and Myanmar. The manifestations of the parties' dispute began in 2018. In May of that year, the Gambia led an effort at an OIC ministerial meeting in Dhaka to hold Myanmar accountable for its brutal violence against the Rohingya group. Myanmar reacted to this development with a statement from its Ministry of Foreign Affairs that, quote, categorically rejected, unquote, the allegations against Myanmar in the declaration issued at the end of that OIC ministerial meeting. 4 months later, on 12 September 2018, the UN Independent International Fact-Finding Mission on Myanmar issued its landmark report finding that Myanmar's crimes in Rakhine State were, quote, similar in nature, gravity, and scope to those that have allowed genocidal intent to be established in other contexts, end quote. The UN fact-finding mission delivered its report to Myanmar on 16 August and gave it 7 days, till 23 August, to provide any comments or reactions. Myanmar provided none. On 25 September, just 2 weeks after the release of the UN mission's 2018 report, His Excellency Adama Barrow, President of the Gambia, delivered remarks at the UN General Assembly. He stated that the Gambia has undertaken, through a resolution, to champion an accountability mechanism that would ensure that perpetrators of the terrible crimes against the Rohingya Muslims are brought to book. 3 days later, speaking at the same UN General Assembly forum, Myanmar's former co-agent in these proceedings, Yu Kyaw Tin Shwe, dismissed the UN mission's findings as, quote, based on narratives and not on hard evidence, end quote. The parties' exchanges continued into 2019, further demonstrating the clearly opposed views of the Gambia and Myanmar. First, OIC resolutions from March 2019, promoted by the Gambia, continued to condemn Myanmar's crimes, including genocide, against the Rohingya and called for accountability. Myanmar, again, officially reacted to these resolutions, demonstrating its awareness of the opposing positions of the parties. Then, in May 2019, in a statement at the conclusion of an OIC summit conference, the member states of the OIC, quote, urged upon the ad hoc ministerial committee led by the Gambia to take immediate measures to launch the case at the International Court of Justice on behalf of the OIC, end of quote. The UN fact-finding mission took notice of the Gambia's efforts and the OIC summit statement regarding a potential claim before this court. In its report of 8 August 2019, the UN mission affirmed its conclusion that Myanmar incurs state responsibility under the prohibition against genocide, and it welcomed the efforts of the Gambia to encourage and pursue a case against Myanmar before the International Court of Justice under the Genocide Convention. Myanmar received a copy of this report for comment 8 days in advance of its publication. It chose not to respond. The UN mission's detailed report of 16 September 2019 was also provided to Myanmar 5 days in advance. Again, Myanmar chose not to respond. The detailed report found that Myanmar continues to harbor genocidal intent and that the Rohingya remain under serious risk of genocide. It also welcomed the Gambia's efforts to pursue a case against Myanmar before the International Court of Justice under the Genocide Convention. These UN fact-finding mission reports demonstrate both the existence and international recognition of the opposing views of the Gambia and Myanmar in regard to Myanmar's responsibility for genocide. And they provide the context for further statements by officials of the Gambia and Myanmar at the United Nations General Assembly meeting in September 2019. At that General Assembly meeting on 26 September 2019, Her Excellency Mrs. Isatou Touré, Vice President of the Gambia, announced the Gambia's intention to lead concerted efforts to take the Rohingya issue to the International Court of Justice under the Genocide Convention. 2 days later, Myanmar's former co-agent, Yu Kyaw Tin Shwe, again dismissed the UN mission's reports as, quote, biased and flawed, based not on facts but on narratives, unquote. And he noted in particular that, quote, the latest reports are even worse, unquote. As the court concluded in its order of January 2020, quote, these statements made by the parties before the United Nations General Assembly suggest the existence of a divergence of views concerning the events which allegedly took place in Rakhine State in relation to the Rohingya. Indeed, that is certainly the case. The Gambia's actions and statements in 2018 and 2019 indicate that it agreed with the UN fact-finding mission that genocidal acts were committed by Myanmar against the Rohingya in violation of its obligations under the Genocide Convention, and that the Gambia would bring a case under the Convention to this court to hold Myanmar accountable under the Convention. It was equally evident from Myanmar's statements and actions that it rejected such findings, which it had described as, quote, biased and flawed, unquote, regarding its treatment of the Rohingya. In sum, taken as a whole, the parties' exchanges at the United Nations demonstrate that they held clearly opposite views concerning Myanmar's fulfillment of its obligations under the Genocide Convention, and that they disagreed about the facts and legal implications of Myanmar's anti-Rohingya clearance operations in Rakhine State. Madam President, by then, there was no doubt about Myanmar's awareness of a dispute with the Gambia over compliance with its obligations under the Genocide Convention. The Gambia's note verbal of 11 October 2019 offers further confirmation. Mr. Staker asked the court to look at this two-page document. I agree. Please do as you deliberate over Myanmar's fourth preliminary objection. It is located in your judge's folder at tab 3. Mr. Staker asked, what facts does it refer to? His answer was, quote, none at all, end quote. That is an astonishing statement. In clear terms, the note verbal invoked the findings of the UN fact-finding mission regarding the ongoing Rohingya genocide, and, I quote, in particular, its findings regarding the ongoing genocide against the Rohingya people of Myanmar in violation of Myanmar's obligations under the Genocide Convention, end quote. Mr. Staker asserts that there was, quote, no suggestion that the Gambia had access to or could itself evaluate the FFM's evidence. Perhaps he forgets that the fact-finding mission reports are public and contain literally hundreds of pages of findings of fact based on direct witness testimony from over 600 victims, satellite imagery, and stakeholder consultations, among other sources of evidence, all of which support its conclusions that Myanmar committed acts of genocide against the Rohingya. Is it Mr. Staker's argument that unless the Gambia had compiled all of this evidence on its own, it could not rely on the UN mission's evidence to assert facts that Myanmar disputed? As regards the existence of a dispute on the law, Mr. Staker says, and I quote, there is not even any positive allegation of the Gambia's own that Myanmar is in breach of international law. Yet again, the text of the note verbal, like the speech of the Gambia's vice president before the UN General Assembly, shows otherwise. The note, referring to the UN fact-finding mission's findings, declared the Gambia's positive opposition to Myanmar's, quote, absolute denial of those findings and its refusal to acknowledge and remedy its responsibility for the ongoing genocide against the Rohingya population of Myanmar, as required under the Genocide Convention and customary international law. In the note, the Gambia rejected in explicit terms, I quote, Myanmar's denial of its responsibility for the ongoing genocide against Myanmar's Rohingya population and its refusal to fulfill its obligations under the Genocide Convention and customary international law. The note even refers back to and specifically incorporates the contents of the OIC resolutions of March 2019, including the language calling on Myanmar to honor its obligations under international law to cease all genocidal acts against the Rohingya. And after noting its view that Myanmar was committing further breaches of the obligations under the Genocide Convention, the Gambia insisted that Myanmar take all necessary steps to comply with those legal obligations, including through making reparations to the victims and providing guarantees and assurances of non-repetition. In summary, the note verbal explicitly articulated the parties' clearly opposed views regarding Myanmar's fulfillment of its obligations under the Genocide Convention and customary international law as it relates to Myanmar's genocidal acts against the Rohingya. Myanmar does not deny having received the note. In this way, it was absolutely aware of the dispute as articulated therein. Madam President, Myanmar's lack of response to the note verbal in the face of grave allegations that merit a response provides further indication that a dispute existed between the parties. 30 days passed from the time Myanmar received the Gambia's note without a response or any indication that one would be forthcoming. On the 31st day, with the existence of a dispute indisputably established, the Gambia filed its application with the court. In reference to the note verbal, Mr. Staker also asked on Monday, I quote, "Should Myanmar at the time have understood it as making a specific legal claim calling for a response?" For this question, we can rely on Myanmar's own representations to supply the answer. Its government spokesperson stated on 16 November 2019 that Myanmar, quote, had expected over a month before that Myanmar could face a suit at the ICJ. Given this clear and unequivocal admission by the respondent state, its contention that it was unaware that a dispute existed at the time that the Gambia's application was filed is entirely lacking in credibility, as is Mr. Staker's argument. Madam President, in the face of this incontrovertible evidence of the existence of a dispute between the parties under the court's well-established standards, Myanmar now seeks to apply new, heightened standards for determining the existence of a dispute. These are contrary to the court's jurisprudence, reflect bad policy, and must be rejected. First, in its written pleadings, Myanmar argues that as a general matter, or at least as regards cases such as this one, the court's alternative grounds for establishing the existence of a dispute must be cumulatively established. Myanmar offers no legal support for its proposal because none exists. There is no case law from the court that would support this position. In fact, this view directly contradicts the court's jurisprudence, which shows that the different ways of establishing a dispute are disjunctive and not cumulative. The court's use of the disjunctive or in listing the various ways of proving the existence of a dispute in Cameroon v. Nigeria directly proves this point. Mr. Staker did not present this argument on Monday, so perhaps it is now abandoned. Second, Myanmar seeks to revisit the court's decision in the nuclear arms and disarmament cases. In addition to the court's holding that a respondent's awareness of the applicant's clearly opposed views would suffice to establish a dispute, Myanmar adds that the applicant must then provide evidence that it was made aware of the respondent's specific opposition to the applicant's claims. No such requirement can be found in any of the court's jurisprudence. Myanmar's imposition of an additional hurdle for the filing of an application would require the applicant state to show that it received an express indication from the respondent state of its opposition to the applicant's claims before it could bring its claims to the court. This, of course, would conveniently allow a potential respondent state to defeat the court's jurisdiction by remaining silent, even when faced with statements by the applicant in regard to a dispute between the two parties that call for a response. Article 9 of the Genocide Convention imposes no such impediment to the exercise of the court's jurisdiction, and there is no reason for the court to invent one. Myanmar's proposal, which would effectively give a respondent the power to exercise a silent veto over the court's jurisdiction, is particularly unattractive in the context of a claim of genocide. If accepted by the court, it would become an instruction manual for how to avoid accountability for breach of the obligations imposed by the Convention, including, as is the case here, for the commission of genocide itself. In this context, Mr. Staker explained that this new standard would require, I quote, both parties to articulate their legal positions to each other before a case is brought. This is to allow, he says, friendly settlement of disputes between the parties. Here, Myanmar has articulated a new negotiations requirement where the applicant would have to give the respondent a chance to articulate its legal views before the possibility of filing an application. Article 9 of the Genocide Convention contains no such negotiation requirement, and neither does the court's jurisprudence on the existence of a dispute. Third, Myanmar asserts that a potential respondent state must be aware of all the facts related to all the legal claims that an applicant raises, as well as the provisions of international law said to have been breached. Myanmar's demand for such quote-unquote particularity about the potential claims, the facts underlying them, and the legal provisions at issue is tantamount to a requirement that the applicant share a draft of the application before it is filed. There is no basis for such a demand. The court's jurisprudence only requires that the exchanges between the parties refer to the subject matter of the dispute with sufficient clarity. Plainly, that was the case here. Both the exchanges at the United Nations and the text of the Gambia's note verbal make the subject matter in dispute clear and obvious. Moreover, the note even specified the primary factual bases for the dispute. In other words, the evidence gathered and conclusions reached by the UN fact-finding mission, as well as the legal instruments and principles at issue, namely the Genocide Convention and related customary international law obligations. Finally, Myanmar also seeks to create a new standard providing respondents with an undefined amount of time to react to an applicant's potential claims, to show an acceptance or rejection of its claims. As applied to this case, they say that Myanmar was not given sufficient time to respond to the note verbal, and that its lack of response by 11 November 2019 did not indicate its positive opposition to the note. But Myanmar's opposition to the Gambia's claims was manifest even before the note verbal itself. Indeed, the note documented that opposition. Myanmar consistently denied allegations of genocide, rejected the reports of the UN fact-finding mission, and rejected the OIC resolutions invoked in the note verbal. Myanmar had 30 days to respond to it before the application was filed, which was ample time to do so, especially in light of its admission on 16 November that it had anticipated the filing of the application for over a month, that is, since its receipt of the note verbal. Madam President, in the grave circumstance of acts that amount to a genocide, 30 days was more than sufficient time for Myanmar to react to the note verbal and deny the existence of a dispute if that were the case. There was nothing new in the Gambia's note that had not already been alleged in the Gambia's statements at the United Nations, which Myanmar had emphatically rejected. Madam President, members of the court, for the reasons I have just given, and also those set out in our written observations, Myanmar's fourth preliminary objection must be rejected. I thank you for your usual kind attention. May I ask you, Madam President, to kindly call Professor Philippe Sands to the microphone to provide the Gambia's final pleading in this round.
I thank Mr. Suleiman, and I now invite Professor Philippe Sands to take the floor.
Madam President, members of the court, it is a privilege and a responsibility to address you today on behalf of the Gambia in a case of singular importance for the court, for the rule of law, and for the international community as a whole. My task is to conclude the first round of the Gambia's submissions in response to Myanmar's preliminary objections. We invite you to reject each and every one of Myanmar's 4 preliminary objections for the reasons set out in detail in the submissions put to you by my distinguished colleagues. Those submissions have set out with crystal clarity why none of Myanmar's preliminary objections pass legal scrutiny. None provides any conceivable basis for this court to refuse jurisdiction or to find that the Gambia's application is inadmissible. Indeed, in brief summary of the points made to you by my colleagues demonstrating the lack of substance of Myanmar's objections. First, the real and only applicant in this case is the Gambia, as Mr. Lowenstein has set out and as the Gambia's agent has compellingly confirmed. Myanmar's argument that another entity should be viewed as the applicant is novel, it's unprecedented, unsupported by any facts, and it's unbecoming. The Gambia is a sovereign nation just like any other. It is not anyone's proxy, and the fact that it is a member of and has worked with an international organization is wholly irrelevant. Second, the Gambia has standing to bring this case against Myanmar. As Professor Dargent has explained, Article 9 of the Convention does not preclude this case, whether as an actio popularis or for any other reason. Indeed, the arguments Myanmar advanced on this preliminary objection are particularly tenuous. Professor Talmon suggested, rather optimistically if I may say, that the fact that no non-injured state has brought an application in the 7-decade history of the Convention may be taken as indicative of agreement by states that they would not have had standing to do so. But no such conclusion can be drawn from that fact. As the court will have noted, the United Nations General Assembly welcomed the court's provisional measures order, which tends to confirm that the body and its member states do consider the Gambia's standing to be established. Yet even that was not the most surprising or the weakest of Myanmar's arguments. How astonishing it was to hear Professor Talmon argue that an application under the Genocide Convention cannot be brought except by a state whose nationals are the victims of genocide. The argument drives a coach and horses through the entire rationale of the Convention, reflecting, as it does, an attempt to address the horrors of the events that occurred between 1933 and 1945. Mr. Talmon's argument would allow states to treat their nationals entirely as they wish. It would remove all protections of the Genocide Convention when a state turns on its own people. Under this approach, a state would be free to annihilate an entire religious, racial, or ethnic group without legal challenge under the Convention, so long as the victims were its own nationals. The argument is ahistorical, it's absurd, and it is totally unsupported by the text or negotiating history of the Convention, as he well knows. We trust the court will consign this argument to the heap in which it belongs. Third, the idea that Myanmar should be able to invoke the reservation it has entered under Article 8 of the Convention to argue for a de facto reservation under Article 9 is entirely fanciful, as Ms. Pasipanodia has explained. As the Court made clear in its order of January 2020, Articles 8 and 9 of the Convention have, and I quote, distinct areas of application, end of quote, and quote, it is only Article 9 of the Convention which is relevant to the seisin of the Court in the present case, end of quote. The preliminary objections phase of a case is not an appeal mechanism from a ruling made in a provisional measures phase, particularly when there's been no change in or understanding of the law to be applied. And fourth, there's plainly a dispute between the Gambia and Myanmar, as Mr. Suleiman has explained. The Court's criteria for determining the existence of a dispute are clear, and the evidentiary record before the Court plainly establish that those criteria were met by the time the Gambia's application was filed. Myanmar's approach to the elucidation of different criteria or standards disregards the Court's jurisprudence. It would give a respondent state, in effect, a veto over the Court's exercise of jurisdiction. The legal position in respect of these preliminary objections is, we submit, clear and obvious. To say that the arguments of Myanmar are tantamount to clutching at straws would be generous. It would require you to redefine both the act of clutching and the nature of straw. As my colleagues have demonstrated, Gambia has brought an application fully in accordance with the rules of the Court and subject to the provisions of the Convention. And in so doing, the Gambia has carefully followed the practice of the Court over its 75-year history. Article 36 of the Statute of the Court, in combination with Article 9 of the Genocide Convention, confers the necessary jurisdiction. So too does the Convention confer standing on the Gambia. It is the applicant in this matter, and its application to the Court is admissible. These then are the technical requirements for the case to proceed, and they are all satisfied in the circumstances of this case. But there is a broader point to make, by way of closing. As Myanmar itself observes in its written preliminary objections, the Genocide Convention is a treaty of singular importance in the history of modern international law, one of the most fundamental multilateral treaties of our time. To have invoked the 1948 Convention is a matter of utmost gravity. It is not something to be done lightly, and I hope you will be able to see that it was not done lightly in this case. The Gambia proceeded very carefully in deciding how to proceed. It took account of reports of United Nations investigators and the inquiries of other third parties. It consulted with other states and with international organizations. It sent its Attorney General, a former prosecutor at the ICTR, who knows a genocide when he sees one, to the camps in Bangladesh to see for himself what was going on, to listen to personal accounts of what was being reported. And the Gambia took independent advice on whether the conditions met the definition of a genocide. On this basis, after reflection and the passage of some time, it decided to act. And this is exactly the conduct that the Convention demands of its parties, and exactly the purpose for which the Convention was adopted. The Court itself has previously observed, and I quote, "The Convention was manifestly adopted for a purely humanitarian and civilizing purpose. It is indeed difficult to imagine a convention that might have this dual character to a greater degree, since its object on the one hand is to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality." End of quote. This Court bears a responsibility in upholding the object of the Convention. As the Gambia observed at the last hearing on this application, this Court, the International Court of Justice, is the ultimate guardian of the Genocide Convention, and the world's eyes are once again turned to this Court. The Gambia is acutely aware of the responsibility that it invokes of you, the court and the judges, and at the same time of its own responsibilities, shared by all parties to the Convention, to promote and secure the Convention's aims. And it is with that responsibility in mind the Gambia has brought this application before the court, abiding by the court's own exhortation to, and I quote, carefully ascertain that all the requisite conditions for the jurisdiction of the court have been met at the time proceedings are instituted. End of quote. Conversely, Myanmar's preliminary objections are frankly in direct conflict with the aims which the Genocide Convention pursues. If they succeeded in whole or in part, they would seriously undermine the value of the Convention and its protections. On Monday, Myanmar evoked the prospect of an unmanageable proliferation, as it put it, of disputes if the court were to find that it had jurisdiction and that the Gambia has standing. Really? Did the floodgates open after your unanimous ruling on prima facie jurisdiction in the provisional measures phase? No, they did not. Will they open if the court, as it surely must, recognises jurisdiction in this phase? No, they will not, because it is fundamental to the Convention and to any functioning legal order that its parties be equipped to hold each other to account by the institution of proceedings before this court whenever there has been an apparent breach. Without that, and if, for example, Myanmar were right that only the most affected party would have standing to bring an application, or, now as it argues, only the party whose own nationals were the victims, the efficacy of the Convention would be so attenuated by the inability to enforce it that it would quickly become a dead letter, and this court would be toothless. An argument that would produce such a result cannot be allowed to prevail. If I may be permitted, it might be helpful to share a brief anecdote to illustrate the significance of the 1948 Convention and this case. In November 2019, shortly before the oral hearings were held in the provisional measures phase, I was in Washington, D.C., participating at an academic event. I shared the panel with a distinguished former judge of this court, the International Court of Justice, a man who had, as a small boy, been imprisoned at the Auschwitz concentration camp under the care of a doctor, one Joseph Mengele. Can you imagine, my fellow panelist at that academic event said, if back then, in the 1940s, there had been a treaty like the 1948 Convention, and a faraway country had invoked it before an international court to argue the inhumane treatment of those held at such a place was not permitted under international law. And that is the stark significance of the 1948 Convention, and of the existence of this international court, and of the unanimous ruling this court handed down in January 2020. No, this court ruled, this kind of behaviour is not permissible under international law. And yes, this court added, we are entitled to decide at this provisional measures stage at the instance of a third state. There was no question of the law of nationality then. Myanmar didn't even advance the argument, it's concocted. There's no proper place for such a concept to be introduced now. Indeed, 2 years on, Myanmar seems to wish to roll the clock back to an earlier era. It wants you to rule that the Genocide Convention and the protections it seeks to afford to vulnerable groups across the globe should be turned into nothing. And we trust this court will not do that. We trust that this court will rule that the 1948 Convention, so carefully elaborated, has real meaning and effect, that it goes to the very heart of human existence, that it seeks to achieve something profound and fundamental in the international legal order by ensuring the right of groups to exist, and to hold to account those who threaten such existence, and by recognizing the right of a third state, which is a party to that convention, to invoke the rights and obligations it proclaims here in the Great Hall of Justice. Madam President, This is not the first genocide case heard by the court. In the previous cases in which this court has heard well-grounded applications alleging breach of the Genocide Convention, it has always resisted the invitation made on each occasion to refuse jurisdiction. It has charted a course that ensures that, and I quote, its basic judicial functions are safeguarded, end of quote. It has held that it is free to show some realism and flexibility where necessary to find that jurisdiction exists, although no such realism and flexibility is needed in this case, where the law is clear and the facts are deplorable. But the court's overture to realism reflects an understanding of the importance of its role and an unwillingness to permit concocted technicalities to interfere with its exercise of its proper judicial function. The exercise of its jurisdiction over the merits shall not be frustrated, the court has ruled. And we ask the court to consider the ramifications if it did refuse jurisdiction in this case. Such an outcome would be seriously damaging to the operation of the Convention and to the international legal order. But alongside that, and more urgently, it would be especially damaging to the Rohingya group. As the court found in its provisional measures order unanimously, there is a prima facie case of genocide. And insofar as the provisional measures serve a protective function, that is because there is a continuing risk of genocide against the Rohingya. Now, you've heard in the submissions from Mr. Reichler about the worrisome developments and conflict that have arisen in Myanmar since the provisional measures order. That turmoil can only increase the risk that exists and the threat which the remaining Rohingya face. It makes it ever more critical that the court proceed expeditiously to the merit stage of these proceedings, and that in the meantime it continues to enforce the protective provisional measures order. Indeed, the change of regime in Myanmar, while concerning on a political level, does nothing to alter the basic legal position with which the court is confronted, either at this stage or subsequently. In respect of the issues with which the court is concerned at this hearing, the jurisdiction and admissibility requirements remain satisfied. There is a clear and compelling case for this application to progress to consideration of the merits. Madam President, members of the court, this brings to a conclusion the first round of arguments by the Gambia. I thank you for your kind attention.
I thank Professor Sands, whose statement brings to an end the first round of oral argument. The court will reconvene on Friday, 25 February 2022 at 3 p.m. to hear Myanmar's second round of oral pleadings. At the end of that sitting, Myanmar will present its final submissions. The Gambia will present its second round of oral argument on Monday, 28 February 2022 at 3 p.m. At the end of that sitting, the Gambia will also present its final submissions. Each party will have a maximum of 1 hour and a half to present its arguments for the second round. As the parties and their counsel turn to their preparation for the second round of these oral proceedings, I take this opportunity to remind them of Article 60, Paragraph 1 of the Rules of Court, pursuant to which the oral statements are to be as succinct as possible. The Court has emphasized this requirement in Practice Direction 6. The parties should not use the second round to repeat statements that they have previously made. The second round is an opportunity to respond to points that were made earlier in these oral proceedings. Moreover, the parties are not obliged to use all the time allotted to them. The sitting is adjourned.
Azadi TV'র কিছু মাসৰ কামিয়াবিত ইদ্দুৰ সফৰত সাথ দিয়াত har subscriber অক্কলৰে বেছি শুক্ৰিয়া জানাৰ আৰু মম্মিকায়ো আৰাৰি ইন্দিলা সাথ আৰু মদত অক্কল গৰিবলা আৰাৰ ফুৱাতি তাইবলা আৰজ গৰা যাৰ আৰু তোৱাৰা তো আৰাৰ হামৰ ফসল লাগি মদত গত্য চাইলে তোৱাৰা হাসাত তো আছে দি জইন্ট বাটন CBOৰা আৰাৰ মদত গৰি ফাৰিবা